here, Honorable Mr. Justice B.A. Patil sir, our beloved Dean, Professor Dr. T.R. Subramania, our beloved Director, Professor Dr. V.J. Praneshwaran sir, faculty members of CMR University, School of Legal Studies, and my beloved friends. I, Shruti Shreya, a student of BBA LLB 9th semester, on behalf of CMR University, School of Legal Studies, welcome you all to the workshop on the art and science of judgment writing. To begin on an auspicious note, I would like to invite Dharani, a student of LLB 3rd semester, to sing the invocation song. Honorable Shri Justice D.A. Patil, a luminary in the realm of judiciary and law, who brings with him wealth of experience and knowledge that spans a remarkable career in the legal field. I would now request our Dean, Professor Dr. T.R. Subramania sir, to kindly welcome our esteemed guests by presenting a bouquet as a token of love and appreciation. Thank you so much, sir. I would now like to invite Yusuf, a student of BBA LLB 5th semester, to introduce our guest for the day.
Justice Patil, born on January 20th, 1959, began his legal journey at the University Law College in Dharwad, earning his law degree in 1983. He quickly established himself as an advocate and gained recognition for his legal acumen. His academic achievements include an LLM degree with top honors and a gold medal. Justice Patil's dedication towards law extended to academia, where he served as a part-time faculty member in law colleges and at Karnataka University, Dharwad. In 2002, he was directly selected as a district and sessions judge. His contributions to the legal field were acknowledged with the prestigious Aryabhatta Award from the Aryabhatta Samskriti Samstha. He also played a pivotal role in the criminal justice reform and underwent specialized training in mediation techniques in the United States of America, becoming a trained mediator. On 14th November 2016, Justice Patil was appointed as an additional judge of the High Court of Karnataka and a permanent judge on 3rd November 2018. Besides his legal career, Sir is an avid reader, writer, singer, and cricket enthusiast. Importantly, his dedication to helping the less fortunate is a testament to his commitment to social justice. His extensive judicial background and commitment to law and justice makes him the perfect guide for this workshop. Sir, the stage is all yours.
Good morning, one and all. My beloved, respected, my good teacher and professor, Dean of CM University, Dr. T.R. Subramanian, and lovely faculty members, my dear students, ladies and gentlemen. I feel it a proud privilege to participate in this function, especially when my guru is the dean and a student coming and delivering a lecture on this workshop on art and science of writing the language. It is also my proud privilege to come to this great institution which has already established its name not only in this country but at the top in the world. My friends, art of writing the judgment, if you take that particular subject, so it is a very difficult task. Usually, in the earlier days, it is the headache of the judges to write the judgment. The advocate used to submit their arguments either on the plaintiff side or on the defendant side or petitioner or respondent side. And the judge has to analyze and write a judgment. So even our school days, that we were not knowing what the judgment is and how the judgments are written, only except by seeing the important decisions for our reference. What is the principles also which have been laid down in those decisions? And only practical aspect which was there is that we have to attend some, that is cases conducted in the district courts or some courts, and we have to write our diary and submit it to the, that too only in third. Now the curriculum has changed. Now the institutions are making you perfect from all angles. There are so many aspirations or ways to take your profession. So you may, that is, start the practice on litigation side, or that you can go on commercial side, or that you can join to a companies as an advisor, and you can also become a judge. So here, that art of that is writing a judgment, it helps all the persons to know how a judge works and how he writes his judgments. So if you know that on what basis the judge is going to write his judgment, then it is very easy for you to convince the judge as an advocate. What fact has to be stated, how that he has to be convinced. Earlier that one saying was there. So you try to convince the judge. So if you are unable to convince, so confuse him. That was the way in which that the things used to be taught. Nowadays that is not. So here, knowledge and wisdom, they play a very important role in your profession. So in that light, so one of this particularly the workshop, so which has been organized by this esteemed institution, used to give you all the inputs how the judgments are written. There are two things that which have been stated in your workshop, that is topic, art and science. Art of writing the judgment is concerned, so there is no specific art. So each judge, so he writes his judgment in his own way. So some formats are there. But so here, that if you read one judgment, so here that he will be, that is explaining the things in a different manner. And so other person, so if you give him a similar facts, so he will write a different judgment. Even sometimes that what we have seen is, so if you see that here about more than 60 students are there, if you give one facts, so you will get a 60 type of judgments, not one. Some may acquit, some may that is convict, and some may say no, that this is the unfit case to be tried and he should be discharged. So many things are there in this particular regard. So here that it all depends upon the perception of a particular person to a particular facts. So that's why. So here, that what is a judgment then? What is a judgment? So if you see section 2 of CPC, so here therein that it has been defined as the statement given by a judge on the grounds for a decree or an order. In other words, a judgment may be defined as a reasoned pronouncement by a judge on disputed legal question which has been argued before him. So here in this particular regard, so here the judgment possesses its own characteristics and its own standards and merits. So here the art of composing the judgments is concerned, it is not taught. It is going to be acquired. So here that I want to reduce a pause for a while and say, you know, under the Indian Evidence Act, so here burden of proof is there. Onus of proof is also there. So what is the difference between these two? Whether they are one and the same or they are two different things. So if you put a question, then so the answer will be, so here burden of proof will be only on one person. Onus is there, so it is going to shift from one to another. So that is a distinguishing factor, that if you know these particular minute things, then So you will be in a position to appreciate a particular facts. Judge, what he does is, so here he has to study the case, apply his mind, and then thereafter that he has to give the reasons for these decisions. So here that a simple reasoning is not necessary, that it must be in accordance with law. So here, that whatever may be reason, sometimes that I say, no, there appears to be that he might have committed a murder. He might have committed a murder. But if you take the evidence and the law, so then that he is going to be acquitted. He is going to be acquitted. So here, in that light, that I want to quote, that is one illustration. A complicated case has been argued before a judge. So it was so complicated. The judge carried all the file to his residence or a house. Next day was a Sunday. So morning 7 o'clock he started reading. So his wife came at about 9 and called for breakfast. Then he angrily answered, I am reading a complicated case, and so here, leave me alone. She left and she went and had her breakfast. Then it was 1:30. So again she came and called him for a lunch. I have already told I am reading a complicated question and that's the facts. So here you are again and again coming and discussing. Then that wife was so wise. Under the criminal law, so if you are not in a position to think and give a decision, give the benefit of doubt to the accused. So she is so simple in answering it. So here, that's why sometimes, so here, which is not going to be struck to a particular judge or a lawyer, so it is going to be struck to a ordinary common man. So that's why, so judgment cannot be said, so in a particular manner, in a particular way, or a particular thing. So that's why it differs. So here, that whenever a judgment is pronounced, it is regarded as an intellectual product and it stands in a class by itself. So many cases that you have already that is quoted. So in such and such a case, that is A.K. Gopalan's case, or that is so and so case. So here, why that you quote? So here they stand by class by themselves. If you let us take that is the ratio laid down in Dana versus Stevenson in torts, or Rowland versus Fletcher. So here, why that they are going to be quoted often? Because that they stand on a intellectual product. Earlier to these decisions, so that there was no law as such, either the manufacturer's liability or occupier's liability. So these things were not there. So here it is the creation of a judge under a particular facts of a case. So that's why what I want to say is, so here judgment that which has been returned and pronounced, it is not only a record to see, but it will be a guiding principle to the society and for the future generations. So here you have also come across so many things with regarding to PIL, public interest litigation. A letter written by accused. So so sitting in the jail. So here it has been converted into a petition and the relief has been. So how it is? Nowadays, many that is public properties and that is public things, especially the Western Ghats and other things. So that is going to be governed by the orders of the Supreme Court. So in that light, so whatever the judgments so which are that is going to be given, so here they are considered to be the standard products or intellectual products. So they are guiding the society as a whole. So in that light, so here that the judgments are there. And the judge speaks with authority. So whatever that is particularly the judgment, so here that he has to speak with authority, and what he says should therefore be spoken with befitting dignity. So here, that's why, so here you might have that is gone through some judgments. So here are in a newspaper. Judge orally told. Judge orally told. So it is not a written judgment, but it is orally told. So here, to that an effect, that the wordings of a judge will be there. So that's why, so here, that in this particular regard, the strength of the judgment lies in its reasoning, and it should therefore be convincing to the parties. So many a times that sir may be in a better position to appreciate. So here, if you read some judgments, that you will not understand tail and head. What exactly he wanted to lay down a ratio, so it itself will be, that is a very difficult task. Whether it is an arbiter or whether it is a ratio. Many judges, so here instead of speaking on the judgment, they speak other things more. So that is not considered to be a correct judgment. That's why, so here in this particular regard, the strength of a judge, so here lies in its reasoning, and it should therefore be convincing to the parties. So one of the, that is the Supreme Court judge, while addressing the gathering that he was, that is telling. So whenever you write a judgment, so here the client should not go to the advocate or the judge to ask its meaning. So if he reads himself, that he should understand, so what has been decided in his favor or against. Some, that is the judges, they quote. So you might have read the judgments of Krishna. Hunch up a bench. So what is going to be understood by this? Jail or a bail? So common man will not be in a position to understand. No doubt that he is highly respected, and his words are that is high, and his judgments are very good. But so here, whether a common man will be in a position to understand those judgments. That's why, so here that in art of that is writing the judgment, so here that it is specifically said, so here whatever you write, so there must be clarity of exposition, and that the language must be so simple so that every common man must be in a position to understand and read it, especially the clients. So that is the main, that is the object. So here, apart from this, the good judgment so attributes a style, elegance, and happy praisings. So here, that in this particular regard, while writing the judgment, so here unnecessary details have to be discarded, and prominence should be given to the material circumstances. Material circumstances. If a divorce case has come up before a judge, a divorce, that is a case come up before a judge. So here, if he starts his that is a family life and what is the family life of other that is people. So here there are so many that is religions. So each religion is having its own that is way of marrying and way of living and other things. So if you go on quoting in this religion, this is, it is not relevant. In that regard, so here that it should be given with material circumstances. So here that in this particular regard, so here that he must also understand that whatever the judgment, so which is going to be delivered, it is a document for a particular person. Take for instance, so here that whatever this particularly the things are there, so here they are going to be determining rights and duties of a particular person on a property. So that will be the basis for him. So in that light, the judgment that is considered to be a most important document to that particular person. So here, if it is important, then the judge must also be that is very careful. So here, while that is exercising his power to write a judgment. So why I am that is telling this because, so here, to become an advocate is very easy. To become an advocate is very easy. So here, that whatever the facts which are there, that you can, that is narrate, and whatever the law which you know, so here that you can. But ultimately, the judge who writes the judgment, that he has to apply all his mind and law. You take for instance, a particular judge writes a judgment by saying that no, that advocate did not assist me. He has only said the facts and he didn't assist me in law. So here I want to that is narrate the things and say no, this case is dismissed. That if an appeal has been preferred, the higher court will comment on him that he do not know the basic things of the law. So that's why whenever a judgment is written, so here it is the document of a judge. So what you will say? If you read a judgment, so here that you say, no, that in Keshwan and the Bharti, so here such and such a judge has written like this. It is not the parties that they are going to be commented. It is the judge who has that is written, he is going to be commented. So here that you are also that is aware of the fact that, so here judgment can be that is analyzed and criticized, it will not be considered to be contempt. It will not be considered to be contempt. So here that in that light, so here there will be so many comments. Nowadays that you are also aware of the fact, so here if any judgment is pronounced, so here so many comments will come. It ought to have been decided like this. It ought to have been taken in this fashion. So why? Because so here that it is a public document. So that in this particular regard, while writing that is a judgment should not be that is ambiguous, and judge has to record the reason for each of the that is the points raised by the parties. So there are so many that is issues what we call. So here he has to answer. So here what is the reason? Reasoning is nothing but it is a rational explanation to the conclusion. Rational explanation. So that's why just now that I have given an illustration where that I said, so here that if you are not in a position to understand, give the benefit of the doubt. So here in that light, so here that the reasoning is the process by which we reach to the conclusion. So here reasoning is a mental process. So here the facts, the law and everything has to be analyzed, and then thereafter, so here the reasoning starts to be there. So here, then in this particular regard, apart from that, judge must also apply the law which is applicable to that particular that is the circumstances and each case is concerned. So here, if the judgment is not supported by the reasonings, then in such circumstances, it is considered to be a not a good judgment. So it is a common sense. It is a common sense. So if you take for example, if you two friends meet somewhere, and if you are discussing something, no, yesterday I had been to that particular hotel, so the food was very fine. Then another will say, no, I also went there, but I felt that it was not good. So how that you felt that is good and how that she felt bad. So here you start explaining with reasons. So judge's position is also like that. So he has to explain his reasonings. Why that he is coming to that particular conclusion and why he is not accepting the arguments of a particular advocate. So in that regard, so here that the reasoning considered to be very supportive for a judgment is concerned. So here, that one more thing is there. While writing the judgments, if you want to rely upon any of the decisions of the apex court or this particularly the high courts, that you must analyze what is the ratio laid down in that particular case, and then only that you have to quote with a single that is quotations or something like that. If you want to extract that particular paragraph, that you have to extract that particular paragraph and that is complete that particular text or quotations. So here only that portion has to be that is quoted, which is considered to be a ratio. So here in a particular judgment, two aspects will be there. Ratio precedent will be there and arbiter dicta will be there. So arbiter is whatever the other discussions which have been made, it is not going to decide a particular case. So here ratio is one thing, so which is going to that is decide a particular case on a particular facts and circumstances are concerned. So that's why judge has to refer. So here that whatever the that is the judgments so which have been quoted by the learned counsel and whatever the law so which has been quoted by the learned counsel, and then thereafter that why that he will come to that particular conclusion that the reasons are. So here, though I have said that there is no specific that is rules or standard of writing the judgment, but there are certain essential things which must be there in a judgment. So yes, that a cause title and other things that I will not touch that particular aspect. So format will be there, that accordingly that. So here, the first that is the thing so which must be there in a particular good judgment is reasons for the decisions. That is, in every judgment there must be reason. Second one is, so here that the judgment must show fairness and correctness of the decision. So here fairness. So here whatever the judgment so which has been written, it must be fair, unbiased, and exclude from arbitrariness and bias, and to ensure that justice is not only done but also seen to be done. So here many a times, so here so judgment is delivered, but it must be seen to have been done. So here justice is a different thing that which cannot be that is said in a particular that words. So in that light, and so here it must also facilitate the higher courts to analyze and appreciate the examination in which that this particularly the judge has come to a particular decision. So one thing I wanted to let us tell you, I had an occasion to that is sit on in an appellate side. A judge has written a judgment. The learned counsel brought to my notice, Sir, I am unable to understand what he has written. So then I summoned that judge who has written it. He confessed, no sir, that I am also unable to understand. So what exactly that he wanted to convey? So that's why that I simply say. So here to write a judgment in your simple spoken language. If you want to communicate anything, how that will communicate? You make it more complicated or you make it more easy? Easy. So here that you might have seen the movie Three Idiots. So here that the teacher asks that is one question, and he replies that I want to take my books and other things in the bag. So here that he technically says when the teacher is not unable to understand. So that's how that the things are that is going to happen. Maybe that you may be having a high language, but it must be communicative. Communicative. If it is not communicative, so here whatever the language which you are going to use, that it becomes a useless language. So that's why judgment is nothing but it is a communication. Communication of thoughts of a judge to the general public or a parties who are before him. So that's why judgment writing, so it requires a skill. And so here that the best way in which that I want to quote is, so here judgment must be like a storytelling. Storytelling. So if a particular case is there, if a murder case is there, how a murder has taken place. So what are the witnesses who have seen and who have that is come and deposed before the court, whether they are the eyewitness or circumstantial evidence, and how that they link to the circumstances. It is a story. If you sit in a movie, how that it goes? It starts and ends. That communication will be so nice. Even though that you are sitting in a theater, so you feel that actually that these things are going on. You feel. No, actually that they are doing like that only. We feel sometimes that we forget ourselves. Oh, actually that these things are that's going on in that. So the judgment must be like that. So if you tell like a story, so here that there will not be ambiguity, there will not be any confusion in this particular regard. So here that in this particular regard, so here that the judge must raise the issues and answer the issues. So here that one more that's the thing that which I want to say is, before writing the judgment, what a judge has to do is, judge must read the facts, full facts, and analyze and think over that, and he should be clear on himself. If he is having a doubt that he cannot give a good judgment, so that's why he must have a clarity what exactly the case is. Then, so here he must clear his own doubts if there are there. Some doubts. So nowadays, what is happening is, so advocates will not fully assist the judge. So some ambiguities and some doubts will be left out. So that's why he must get it clarified, and he must be sure what he wants or wish to write, and thereafter he has to write it. Then only that it will be a perfect and a clear judgment. That's why that we say. So if you yourself is confused, how that you will be giving a good reasons or so here in that light. So there is no preparation sometimes starts a different angle, so here concludes it a different. So in that light, so here that while writing a judgment, the judge must summarize the evidence. First he has to say that is fact, what has happened, how the things have happened, what is the controversy, and what evidence has been given. He must summarize. And whatever the documents which have been produced, so here that he must also quote. And so here that he must avoid quoting that is long quotations, which lead to lack of understanding. While writing the judgment, the judge has to use the simple sentence and should not have discussed the complicated discussions. And the judge must use complete grammatical correct sentence. So I will tell one that is an instance. Because of that I have that is sat on judicial side many years. So you get one that is a case. It was a rare case. So usually doctors will write the medical certificate. There is nothing to suggest that the accused is incompetent to have a sexual intercourse. There is nothing to suggest that the accused is not competent to have a sexual intercourse. What is the meaning of this? There are two negatives. So it makes one affirmative. So judge, by thinking that there is nothing to suggest, he read that much. So he came to the conclusion that so the person who is accused is that is important, and that's why how we can have a sex with this lady. So that's why he acquitted. So state that is preferred an appeal. So while deciding, I looked into. So here he has not understood what is the meaning of that particular certificate itself. So that's why. So here that whenever a judgment is written, he must use complete grammatically correct sentences, and he should not quote unnecessary words, and judgment must be in a spoken language, and it must be like talking to the readers like a story reading, and while quoting the decisions they should be quoted within single or double quota, and they shall be highlighted to attract the readers. That's how that is particularly done. So here, one that is the thing that which you have to that is keep in your mind is there are two types of judgments. One is judgment in rem, and another one is judgment in personam. So here that I want to that is make it more clear here that whenever you want to write a judgment in rem, that you must be more and more cautious. So it is going to affect the large community as a whole. So if that is a judgment in personam is there, so it is affecting two parties only. So you take for instance in a public interest litigation. So there are so many issues that which will come up before the court. Nowadays, that every that is issue is reaching the Hon'ble Apex Court, and that they has to decide now. So here that it must be very careful while that is answering these points. So here in that's the regard. So here that the one that is the things that which you have to keep in mind is so you must be very very careful. So in case of judgment in them, not in both the cases that you must be careful. But so here more care has to be taken. More care has to be taken in this particular regard while writing the judgments in them is concerned. So here, one more thing has to be that is caution. So here, while writing a judgment, the judge has to keep in mind. So the Latin maxim "nemo debet est judex" and "propria sul causa." So which means that no man can be a judge in his own cause. So he cannot that is sit on his own cause and give a judgment. So in our constitution also it says, and even in jurisprudence also it says, and even in all other texts also. So yet that a judge cannot be that is of his own cause. So that if any such things are there, that simply he has to recuse from the writing the judgments. So here, and one of the Supreme Court, that is the judge, he has that is said, so simple writing is the hallmark of superior mind. Simple writing is a hallmark of the superior mind. It is not easy. So to make it that is simple, so here that you must have a mastery over these things. And you must have, that is read many judgments of the Privy Council. Nowadays the judgments runs in pages or in volumes. But if you read the Privy Council judgments, so maximum, very big judgment is only in 2 pages. How they used to write like that? So here, a person who is perfect in presse writing, that he will be a perfect judge. Earlier that it was there, presse writing, giving 2 pages and write it in one paragraph, everything. Nowadays that it is not there. Nowadays the judgments are written like this. No. What has been stated in plain, that the stenographer will, that is, type it, and what has been stated in objection, that it is going to be, and issues that there, whatever are there. So then thereafter judge starts reasoning. Earlier it was not that. So concisely used to say the facts within 2-3 lines. And what are the, that is the analysis of the evidence and other things. And so here 2-3 paragraphs his reasonings and reasonings. They are considered to be very, that is a good judgment, especially Privy Council judgments. So in that light, so here that simple writing is the hallmark of superior mind, and it is not easy. So always try to use the plain and familiar words to, that is, catch the reader's attention. Judge may understand the difficult words, but they may be difficult for the readers and a common man. So that's why the readers or the parties have neither, that is, patience nor time to go through the, that is, dictionaries and so here read the judgments. So many a times that some judgments are there. So even if you are, that is, going to participate in moot competition. So here some judgments are there. So you have to, that is, keep the dictionary by the side of that judgment, and so here one line you read and that what is the dictionary meaning, then you have to understand. So that is not the purpose. The judgment must also be clear with reference to the facts, decisions. Otherwise, it becomes a very difficult for the purpose of execution also. So here that one Patna High Court has said, the judge must write a judgment. The judge must write a judgment. He must see that it is executed. His judgment is executed and implemented. So if it is, that is, not implemented, so here that it becomes a waste paper. That's what he has said. So that's why, so whenever you write a judgment, so here that it must reach the finality. So in that light the judgment must be there. So here when it becomes a final, so here that if it is covering in all perfect manner what is required in a particular judgment. So if nothing is there, so here even one that is the case that I came to know that so here the Supreme Court has made an observation. The judge has answered all the issues. What more you want to say? Is there any new thing is that you mentioned? He said no. Then the question was asked. So that is the hallmark of a judgment. That is the hallmark of a judgment. So here with these words that I thank that our dean and faculty members for having given me an opportunity to share whatever the few, that is, the thoughts which I was having. Though I was a little man, so I have been brought here and share my, that is, views. So thank you very much to one and all.
Thank you so much, Your Lordship. It was truly enlightening. I now request our beloved Dean, Professor Dr. T.R. Subramanya, to kindly offer his closing remarks and propose the vote of thanks.
Honorable Justice Sri B. A. Patil, Professor Srinidhi, and dear students, you have heard with rapt attention of what the Honorable Judge has said. There are several things he has made by way of observation, and you have to take it, all of them are seriously. The last part of the story is any judgment which is written by a judge must be implemented. And if it is not implementable, remember, it tantamount to vagueness. A judgment is not supposed to suffer from vagueness. This is one of the points most important. Now, I will just give you, since you know each other very well, one or two important developments that have taken place in a few cases. Sir has said about Donald versus Stevenson. Donald versus Stevenson is one case, and the other I shall give you. And this case happened to be a case which was decided by the Permanent Court of International Justice. And the name of the case is Lotus. Those who have studied international law will be knowing Lotus case. What is it like? I shall just tell you in 2 sentences about the facts of the case. Now, Lotus happened to be a mail steamer, taking its voyage from the port of France to the port of Constantinople. It was a public vessel, and it was controlled by the state of France. That is why it is a public vessel. When the ship, the French mail steamer, was about to leave the port of Constantinople, it met with an collision. And it met with a collision of a Turkish vessel by name Bosco. And immediately, remember, the Turkish vessel Bosco went underneath the sea, and 8 Turkish nationals lost their lives. And unmindful of this incident, the French mail steamer enters the port of Constantinople. When it entered the port of Constantinople, the Turkish authorities came and arrested Mr. Demons, who was the captain of the vessel, because he was a really demon. And for his negligent activities, 8 Turkish nationals were killed. They were charged under the Turkish Penal Code, Section 6 of the Turkish Penal Code. And when they were charged under the Turkish Penal Code, remember, the state of France objected to the jurisdiction exercised by Turkey. The state of France said it is a public vessel. It is a floating island. Public vessel is considered as a floating island in international law. How dare you are to exercise jurisdiction on a ship which is part of our territory, French territory. Since it is a floating island, it is part of the French territory. Now afterwards, remember, the matter, this compromise was not possible, the matter goes to the International Court of Justice. And before the International Court of Justice, the International Court just asked the state of France to produce evidence. So you are saying that it is a state-owned vessel. It is a public vessel. And the state of Turkey is not empowered to exercise jurisdiction. Come on, produce evidence. Because it made a mistake by saying, under customary rule of international law, in all collision cases, the ship's flag state, that is the state of France, is empowered to exercise jurisdiction. Now you have stated the customary rule of international law. Why don't you bring in the state practice and the incidents and the instances before the court of law? Now it made the statement, but then it was not able to prove the case, because remember, the state practice at that time was consistently inconsistent. So the result, the claim was paid was fantastic. Now the purpose of raising this is, when I was a student in the School of International Studies, Jawaharlal University, the concerned eminent person was teaching international law one day, brought the case, Lotus case. Having brought the Lotus case from the decision of the Permanent International Court, the court decision, he gave us, could you please find out the ratio dissidently, the reasons for the decision of the court. And he just, all of us, there are 6 of them. At that time, only in a year, only 6 students could go to their MPhil and PhD to Jawaharlal University School of International Studies. All of them, then he went out. He said, I will give you 1 hour. Be here, have some other work. After 1 hour, we came and we all of them sit, and because the judgment was with us, we are not able to say. The judgment was running into 600 pages. Then afterwards, he looked at us. Then he said, he removed 1 sentence. And 1 sentence from somewhere, page number 400 and all. He said, there is no rule of international law which prohibits Turkey from exercising the jurisdiction. This is the ratio decision. See, there is no rule of international law which prohibits Turkey from exercising the jurisdiction. But he said, this is where a lawyer arguing the case either before the High Court or before the lower court or before the International Court of Justice should be point out instantly and instantaneously and say this is the ratio decision of the case. Now I will give you 1 more case. It was interesting, we have raised interesting issues, because as a student we used to study this, and as teachers we have been telling many things. With Patil, we have been boring Professor Patil also. So, because he was a professor, essentially. From there he became a judge of the High Court. Now 1 case happened to be the Hon'ble versus Stevens case. Students who have studied the law of torts will have studied the Hon'ble versus Stevens. Now this was a case which has taken place in the state of Scotland. Those who have not studied the case, for them, for their benefit, I will tell you the facts of this. I studied long back. You will be surprised if I say it is nearly 45 years. Remember, but still I remember. Now, both a boy and a girl go to a hotel. Having gone to a hotel, remember, they order for ginger beer. And remember, both of them were interested in talking to each other, raising certain points. And they were not bothered what they were eating, except for the fact that they ordered, they knew what they had ordered. That's why no further. And remember, the fellow opened a bottle, and in those days, I'm telling you, it is 1929. Remember, beer actually was put in not in a mug like, in a tumbler. And it was put. And remember, a portion of the beer was actually consumed by the parties. Then they ordered the concerned person who was serving the beer to come and put the remaining part of the beer into the tumbler. And a tumbler made out of mud with beautiful colors and all. And when it was about to be poured, remember, a snail, actually a dead snail, came out and it was put in. So at that time, remember, both of them got up from there. Because all of them, they realized that something is going to happen because part of this is already inside. And they did not check properly. And remember, the Scottish lady got upset because she was the one who drank first. And the other fellow who was giving an opportunity to drink her because they were lovers. So what has happened was the lady started thinking, no, you are telling drink, drink. Now I am telling that till the drink drinks you. So the lady wanted to go to the court of law, and the matter, she files an application before the Scottish Court of Appeal. And the Scottish Court of Appeal, they said she has no cause of action. The judgment was simply dismissed. And remember, all the appeals from the Scottish Court of Appeal would go to the House of Lords. And most of the lawyers in the House of Lords were arguing the case. They went to the extent of finding out she has no cause of action. And she will not be able to win the case. But then there are certain lawyers now who take up the case voluntarily and put up the argument. Now the case came up before a 3-man judge. And Lord Atkin happened to be the Lord Chancellor of England at that time. Now Atkin was finding it difficult. And he asked the concerned advocate to examine and analyze the case. Now examining and analyzing the case is simply this. Now if it is, suppose for example, a particular type of drink which is prepared in Scotland, which is known for drinks. And remember, after the preparation of this drink, it is being packed nicely. And after it is being packed nicely, it is sent to other countries of the world, that is to the rest of the world. Now, Shiva's Regal, if it is manufactured in the state of Scotland, and thereafter, remember, it is kept under the mud for 12 years. After 2 years, the drink is being taken out and then it is packed. And then it will be sent to other countries, maybe to the United States, maybe to the state of Soviet Russia, maybe to the state of India. So then it goes to, remember, to the main manufacturer, it goes to the main dealer. From the main dealer to the retail dealer. From the retail dealer to the concerned shops to order for the drinks. You take it this way. Now in a hotel you sit. Now first is there will be a main dealer who manufactures, who gives this to the main dealer, and the main dealer has a list of Indians who are purchasing and Americans, all countries. Then it comes there. From there they will say retail dealers will purchase, and from the retail dealer in each locality, Bengaluru, it will go there. From there the hotel is on order and get the drinks. How do you fix the liability? This is the question. Now the last, remember, the opener may be one of us, like a person, remember, who is studying here but he has no source of income. And he works in a hotel. And according to the order that is being given, he opens and puts it there. But the intermediaries may be 10 or 15 or 20 in a few cases. So having heard the argument, the great man, great judge, remember, he said, I am going to frame a question now. And the question is simple. And this quoting, which is a judicial process, it is not the subject. If the manufacturer manufactures an item, see, listen carefully. If the manufacturer manufactures an item, knowing fully well that the item prepared by him reaches the ultimate consumer without intermediary examination, then the manufacturer is liable. So what he said, how do you fix the liability? See, it is manufactured there. It is packed in the state of Scotland. And afterwards it comes to the state of Goa. And you are just go there for just enjoy and order it. If the manufacturer manufactures an item, knowing fully well that the item manufactured by him reaches the ultimate consumer without an intermediary examination, nobody has opened that box. Nobody has attempted even the box as it is. The hotel owner, remember, tells the concerned person to open it and then take the bottle. This is wrong. Remember, that fellow was convicted. Everyone went on saying there is no cause of action. Then, ultimately, Lord Atkin was able to find a cause of action and he was convicted. That is why it is the ingenuity of the judge. And many judgments of this type you have. Lord Kemp, the Lord as well as the barrister Kemp used to say, 90% of the cases are won by argument. And 10% of the cases are again lost by argument. Because either you have not argued or you have not properly highlighted the basic issues which are material facts, which are relevant to the judgment. This is what Honorable Judge has said. Material facts, if they are not cited, naturally, remember, you have actually not made the homework and not cited what is relevant. So these are a few of the issues, many things can be spoken. I sincerely thank Honorable Judge B.A. Patil for having accepted our invitation and for being with us thus far and delivering. Else, I thoroughly well prepared speech to the benefit of all of you. Once again, on behalf of the university, I give from the CMR University with best wishes to all of you. Thank you.